All right, I know there's a few people who are still to join us, and they will drift in. I think people have decided to put snow shovels in the back of their car for later today, but luckily we'll have a warm, dry, and hospitable climate inside today. And of course, it's a great pleasure as Dean of Osgoode to welcome everyone to this symposium, and it's typical of John McCamus's style. It will be both substantive, rigorous, but also breezy and entertaining. So not to put too much pressure on the speakers of the first panel, but it's very much meant to be a day about the work and the thought of John, and I know everyone who's participating has taken that as their point of departure. Jamie and Stephanie, as many of you know, Jamie Cameron, Stephanie Benishai have been the architects of these panels, and they asked, since they'll have other occasions, to come up and speak a bit more about the day and the people who collaborated on making it possible that we jump right into the first discussion. So with again a sentiment of the great pride we take in John and in today, and with lots of occasions to come to reflect on various aspects of his scholarship and his work, let me invite the speakers for the first panel to come up to the stage, and we'll dive right in.
Good morning, everyone. Can you hear me? Microphone's at Lauren's height, which is a little bit higher than my height. So thank you for making it out on this snowy, not yet fully snowy morning. My name's Stephanie Benishai, and I'm going to be moderating our first session this morning, which is on contract law, and it will follow the substantive, less breezy style that Lauren referenced. I'm delighted to introduce you to our three speakers. First speaking will be Professor Stephen Wadhams. The title of his paper is Mistake in Assumptions. Stephen is well known to this group, but he is the Goodman Shipper Professor of Law at the University of Toronto and also a university professor. He's a graduate of that law school, amongst many other degrees, and a fellow of the Royal Society of Canada. He has visited at numerous other schools, including being a visiting fellow at Oxford, numerous occasions in Cambridge. He has received multiple awards, including the CALT Award and the Law Reform Commission of Canada for his contributions to legal research, as well as awards for excellence in teaching from the law students of the University of Toronto. He's been awarded multiple book awards as well, including the David Mundell Medal in 1996, as well he was awarded a Killam Research Fellowship in 2000-2001. He has published over 150 articles, book chapters, review essays, as well as more than 12 books, with one of the most recent being Principle and Policy in Contract Law, Competing or Complementary Concepts. Beyond his specific research interest in contract law, his research interests are related to legal history and 19th century English ecclesiastical courts. The next speaker will be Professor Michael Pratt, who has made his way here from Queen's University. and describes himself quite modestly, although there's much more to say. His one big claim to fame here is that he was once a student in Professor John McCamus's first-year contract course. He more recently is an associate professor of law at Queen's, where he's cross-appointed to both the law school and philosophy departments. His research is devoted primarily to understanding the philosophical foundations of voluntary obligations, such as those generated by contract, promises, and agreements. He too has published widely in his main research areas, and in addition and in his free time, he publishes on tort law and the law of remedies. Commenting on, and oh, sorry, I should say that the title of Michael's paper is The Intention to Create Legal Relations and Disclaimers. And our third speaker, who will be commenting on Michael and Stephen's papers, is Angela Swan, who's also well known to the group. In her previous life, she was an academic for a long time at the University of Toronto, both as a full-time faculty member and as a part-time faculty member, and also at McGill. She's also been in practice for a long time, where she was a partner, now currently counsel at Aird and Berlis, an associate at Stikeman and Elliott, and also previously at Aird and Berlis. She's taught at other institutions as a visitor, such as the University of Victoria, and we're proud to count her as an adjunct faculty member here at Osgoode, where she teaches a popular follow-up to John's first-year contracts, which he also teaches sometimes too, the upper year or advanced contract law course, as well as another course on business acquisitions with a colleague from Aird and Berlis. Her major teaching and research interests are in contract and conflict of laws. She too has published extensively, and her main focus in her practicing life is mainly the corporate commercial area, and she focuses in particular on drafting, administration, and interpretation of contracts of all kinds. And her claim to fame here is that she taught both John McCamus and Stephen Wadhams. So with that, I'll turn it over to our first speaker, Stephen.
Thank you very much, Stephanie, for that kind introduction. I have chosen as my topic a mistake in assumptions. This was a category, I believe, first put forward by the American scholar George Palmer in 1962 in a book entitled Mistake and Unjust Enrichment. Like John McCamus, George Palmer wrote both on contract and on restitution or unjust enrichment. And this topic, mistake in assumptions, is one that touches on both, or draws from both, or brings to the forefront the necessary interrelationship between ideas of contract on the one hand and ideas of avoidance of unjust enrichment on the other hand. Mistake in assumptions, Palmer suggested, is a category that it is important to distinguish from mistake relating to the terms of a contract. So the concept of a mistake in assumptions is of a mistake as to a fact that induces the making of a contract, but where there is no mistake as to the terms of the contract itself. You and I agree that you will buy a piece of land for a certain price. There's no mistake as to the terms of the contract, but you are induced to enter that transaction by an assumption that turns out to be false. An assumption, for example, that the land is suited for some particular purpose that you have. Now, Palmer, in 1962, when he came to deal with the topic of mistake in assumptions, suggested that the crucial considerations were avoidance of unjust enrichment and allocation of risk. Palmer's thinking has directly influenced the second restatement of contracts, as it is acknowledged in the reporter's note to that document, and has been generally accepted in American jurisdictions. However, it has not yet been fully adopted in English or Canadian law. John McCamus has largely accepted Palmer's framework of analysis in his two treatises on contracts and on restitution, and he argues very persuasively and effectively in favor of its adoption by Canadian courts. His treatment of the law relating to mistaken assumptions is, in my opinion, really excellent. He combines an accurate account of the actual law, past and present, with cogent critical analysis in readable and interesting form, and does all this in a way that constitutes a model for academic analysis, while at the same time successfully addressing, and what's more to the point, actually influencing judicial decisions. A recent decision expressly adopted John's view on an important aspect of this matter quite recently. Unfortunately, for a writer or speaker seeking an easy and accessible way in which to present the issues, an examination of the relation between common law and equity cannot be avoided. Before the Judicature Acts, which came into force in England in 1875, 1881 in Ontario, the courts of equity had an undoubted power to rescind an agreement for mistake. But although the power was undoubted, its limits were ill-defined. The power of the court to rescind a contract was, like all equitable remedies, discretionary, and the discretion would not be exercised in the absence of what seemed to the court to be sufficient reason. After the Judicature Acts, it might have been expected that the new court, uniting as it did the powers of the courts of law and the courts of equity, with equity expressly stated to prevail in case of conflict, it might have been expected that the new court would exercise the power of the former court of equity to rescind contracts for mistake. However, despite the Judicature Acts, there was a reluctance by English writers and judges to recognize the full breadth of the equitable power to rescind for mistake. George Palmer put it this way, writing in 1962, "In modern times, English judges have sometimes remembered earlier English equity, but often, it seems, either forgotten or consciously discarded." The main reason for this reluctance was probably that the limits of the equitable power had not been clearly defined, and so recognition of the power without the ability to state clear limits appeared to jeopardize the stability and certainty of contracts and was out of keeping with the desire prevailing in the late 19th century and 20th century also in England to achieve a high degree of predictability and certainty in legal rules, combined with a deep suspicion of discretion in judicial decision-making. A related reason was that it appeared unnecessary and therefore undesirable to separate the concept of relief for mistake from that of contract formation. It appeared to be an attractive simplification to apply a single principle, that of consent, to both problems, both the problem of contract formation and the problem of relief from contracts entered into by mistake. And this apparent simplification seemed to eliminate altogether the need for discussion of the old equitable jurisdiction. So you can see the seductive attraction for a writer in 1876 who was Pollock, Frederick Pollock, who published his first edition in 1876. It seemed an attractive simplification to say, well, now the old equitable jurisdiction is behind us, we can forget about all that, and we have a simple principle to govern contract formation and mistake, and that principle is consent. But looking at the question in terms of contract formation was wholly alien to the methods of thought of the old equity cases. Equity intervened in order to prevent an unconscionable result, but not because the contract was void. On the contrary, the contract was assumed to be valid at law, and that was precisely why the intervention of equity was both justified and required. Simplicity is a good thing, all other things being equal. But oversimplification is not a good thing, and in the end defeats its own object, because it leads to complexities when it turns out that the oversimplified remedy is not appropriate for what it's supposed to deal with. The apparent attraction of a single simple principle, that is consent, to resolve this problem ran into two fundamental and related difficulties. The first was that adoption of consent as the sole determining test had the effect of excluding other relevant dimensions of the question. These might be summarized as whether the risk of the mistake could fairly be said to have been allocated by the contract to the mistaken party. The same point might be stated in terms of whether the promisee had a reasonable expectation of receiving the benefit of the transaction, and whether any enrichment caused by enforcement of the transaction should be considered unjust. So these various perspectives are interrelated. They're different ways of looking at the same question. The second and related difficulty was that a test based solely on consent was potentially far too wide. Almost every disadvantageous contract involves a mistake of some sort. And in almost every case, it is possible for the disadvantaged party to show that in the absence of a mistake, the contract would not have been made. To set aside contracts for this reason alone would undermine the security of transactions. The loss of the equitable perspective on this question had other consequences. The concept of a contract that is not necessarily void, but that may be set aside by the judgment of the court for sufficient reason, that is, voidable, admits the possibility of various intermediate solutions. First, it admits the possibility of enforcement by the mistaken party if that party so chooses. Whereas if the contract is supposed to be void as though it had never existed, it would seem that it is a nullity for all purposes. But the equitable perspective allows a choice to the mistaken party to enforce if that party chooses to do so. It also admits the possibility of partial relief or relief on terms, which the court can fashion in order to meet the justice of the particular case. And it admits the possibility of denying or restricting relief in order to protect third persons who may have relied on the validity of the contract. These important objects were familiar features of equity, but they tend to be lost if the only and decisive question is formulated in terms of whether the contract is void for lack of consent. One of the hidden effects of the adoption of consent as the sole test for mistake in English law has been the loss of important elements of flexibility that had existed in English law as it was, taking the two systems together, on the eve of the Judicature Acts. This loss of flexibility was not intended or authorized by the Judicature Acts, and partly because the former equitable flexibility has not been fully recognized by modern English courts or English writers, no serious attempt to justify its removal has ever been advanced. In 1932, the House of Lords decided a case, Bell against Lever Brothers, which, though it's open to various interpretations, was widely understood to lay down a very narrow ground for relief for mistake. I won't trouble you with the facts of the case, which are probably well known to most of you in any event. So this was taken as imposing on English law a very narrow view of relief. In 1950, the English Court of Appeal attempted to revive the old equity jurisdiction, and they had considerable historical grounds for doing so. But by 1950, a lively historical understanding of the powers of the Court of Equity before 1875 had been lost. A whole 2 generations had passed, and so English writers and judges were not as fully conscious at that date as they might have been of the earlier powers of the Court of Equity. And in 2003, the same court, the English Court of Appeal, rejected the 1950 case and attempted to reinstate the very narrow view that had been laid down by the House of Lords in Bell against Lever Brothers. It is a curious irony that the equitable jurisdiction, which was supposed to prevail after 1875, should have been suppressed by reliance on the very feature, that is, validity of the contract at common law, that had given jurisdiction to the courts of equity in the first place. Wherever equity intervened to set aside a contract, the contract was valid at common law. If it were not so, equity could not have intervened. John McCamus has criticized the 2003 decision, which is known as by the name of a ship, The Great Peace, in an influential article and in his treatises on contracts and on restitution. As he persuasively shows, the actual result in The Great Peace was readily justifiable in the circumstances of that case on the ground of allocation of risk. There was no need for the court, in enforcing the contract, as they rightly did, to seek to reverse the 1950 case that I mentioned. And Lord Phillips, who gave the leading judgment, actually conceded that a wider ground of relief than recognized in Bell and Lever Brothers was desirable and necessary, and actually suggested legislative reform, which is a curious mixture of contradictory ideas, that the court should reject the 1950 case and then immediately call for legislative reform to reinstate it is distinctly odd. And this is what, in effect, the court was doing, because any legislation is bound to give a broad discretion, the very thing that the 1950 case had given, and that the House of Lords in the Great Peace was purporting to reverse. John McCamus, with admirable restraint, describes this comment of Lord Phillips as particularly unhelpful in the Canadian context. And I fully agree with that comment, because uniform law reform, or indeed any law reform on this issue, in the Canadian context is highly unlikely. And even in the context of English law, it seems regrettable, and there is a reasonable prospect that the United Kingdom Supreme Court may, for this reason, eventually reject the reasoning in The Great Peace. A modern English writer, Sir Gunter Treitel, wrote in his discussion of the case that the American rules on this subject are much closer to those of English equity than to those of the English common law. Treitel, recognizing, like Palmer, the significance of earlier English equity and its unjustified neglect in 20th century English law. And Treitel added, the American approach does not seem to have caused widespread inconvenience. And in the following edition, these words were repeated, together with the express suggestion that the House of Lords, which was then the highest court, now of course the United Kingdom Supreme Court is the relevant court, might overrule the Court of Appeal on this question. Now, in the few minutes that remain to me, I just want very briefly to suggest some implications that follow from the recognition of Palmer and McCamus's suggested approach to the question of mistake in assumptions. One is, well, I've already mentioned the potential flexibility. Second, the whole topic of misrepresentation will appear in a new light if a broad ground of relief for mistake in assumptions is recognized. Misrepresentation has caused enormous trouble to English law and has been neatly resolved by a recent European harmonization document, the Draft Common Frame of Reference, which in a few words neatly resolves the problem of misrepresentation by providing that a party may avoid a contract for mistake if the other party caused the mistake. So looking at the problem of misrepresentation in the context of mistaken assumptions leads to a simple, neat, and elegant, and in this case effective, solution to the vexed problem of misrepresentation. The other aspect of the law, which will appear in a different light if mistaken assumption is recognized as a ground for relief, is the branch of the law generally referred to by English and Canadian lawyers as frustration. Palmer pointed out, and John McCamus also pointed out, and I agree with them, that there is a very close similarity between mistaken assumptions and frustration. Indeed, I'd go a step further and say they are identical from the point of view of justice. In both cases, an assumed fact that induced the transaction has turned out to be non-existent. In the one case, a mistake as to an existing fact, and in the other case, a mistake as to future events. Yet, ironically, English law has been quite generous in granting relief for frustration, though, as we have seen, decidedly reticent in its willingness to grant relief for mistake. If the two are looked at together, it will, I think, benefit both branches of contract law and bring together aspects of contract law that can beneficially be seen together, and then to which can be applied flexible solutions for the purpose of giving partial relief, which may be necessary in both cases, and for protection of reliance and restitution that may have occurred in pursuance of the ineffective transaction, matters that have not satisfactorily been resolved in respect of frustration, though at least they have been recognized, and which can beneficially be seen together in the context of mistake and frustration. To conclude, I would say that this subject demonstrates both the beneficial power of good academic analysis in law and also the dangers of neglecting such academic analysis. The best academic writing, as by George Palmer and John McCamus, is capable of clarifying thought on important theoretical questions, while at the same time assisting the courts in the practical administration and development of the law. Doctrine, history, practice, and theory in law are interrelated. And this is an interrelationship which has been both illustrated and fostered by the scholarly work of Professor John McCamus. Thank you.
I'll see it. Good morning. So as Stephanie mentioned, I was many years ago a first-year student in this law school. It's changed a lot since then. And despite it being so many years ago, it occurs to me not infrequently that a large part of what I do these days, all these years later, is a product of, no doubt, an arbitrary decision by some administrator at Osgoode at the time to place me in Professor McCamus's first-year contract section way back then. I couldn't have known it at the time, but having been in the business for a while now, it's all too clear to me just how rare is the quality of instruction Professor McCamus provided to his charges in that first-year class back in 1991, and no doubt ever since. Professor McCamus took us, there are various aspects of that first-year contracts course that remain prominent for me. Professor McCamus took us seriously as engaged future participants in the making of the law. One got the sense in his class that one wasn't engaged merely in the academic study of law, but that these arcane doctrines we were looking at and our understanding of them would perhaps someday actually make a difference. But what was most striking for me about that course is the other side of that coin. It was what Professor McCamus conveyed to us about what it was to engage in a serious academic study of law. I knew there were these individuals out there called law professors who presumably knew a fair bit about the law, but it hadn't occurred to me that one could subject the law to the sort of rigorous, exacting, uncompromising scrutiny that professors of philosophy say, or professors in the sciences apply to their subjects. But there it was being done in front of us, and we were being encouraged in that classroom to do it ourselves, to take these cases as arguments in favor of propositions, to criticize those arguments, to assess whether they were right or wrong, good or bad, justifiable or not. And Professor McCamus did this with us, and he didn't remain within the bounds of contract either. I mean, I remember distinctly constantly moving outside of contract into tort and restitution, equity and property and everything in between. And it was exhilarating. And there is no single course I took in law school that more influenced my decision to study and make a life of studying, a career anyway, of studying the law seriously than Professor McCamus's first-year contracts course. And so It wasn't just the study of the law. There wasn't just the sense of what it is to take the law seriously. It was contract law in particular. So it's no accident I ended up studying contract. There were some detours along the way, perhaps due to the grade I received in his course. He said he was a good professor. I didn't say he was all that good at marking exams. In any event, I came away from contracts with a deep sense that this was a topic, this was a subject that was challenging, that it was venerable, that it was fundamental, and even deeper sense that if one could get a large enough view of it, as I sensed Professor McCamus had, and that I desperately wanted, it would actually look quite beautiful. And there was no other course in law school that I ever took that I came away even remotely feeling that way. And that may be a product of contract. It may be the case that there is no other subject that is capable of leaving that impression on a student. I'll leave that alone. But even if contract is a jewel in the common law, it's a rare professor who can convey the sense of beauty in the subject as Professor McCamus did. So with that sort of brief introduction, I want to pay tribute to Professor McCamus, to the professor who taught me the fundamentals of contract law by talking about, by examining one of the fundamental precepts of contract, and that is the intention to create legal obligations, or the intention to create legal relations. Professor McCamus conveyed in that first year classroom and in all his writing a deep sense of respect for the common law tradition, for precedent, but it was always mixed with the clear idea that one pays respect to the common law by asking it constantly to justify itself, and by taking its answers and by questioning them relentlessly and in an uncompromising and rigorous way. So I hope that this paper and what I'm going to talk about today reflects some of that sense of respect through rigorous scrutiny that I first imbibed in that first year classroom. So legal orthodoxy, I think it's fair to say that it is just so much legal orthodoxy that a contract can't be created unless there's an intention to create legal relations. It is this sense that contractual obligations are voluntary that marks contractual obligations off from other obligations on the map of civil obligations, those in tort and restitution in particular. Liability in contract is traditionally understood to be voluntary. Now, what is it to be voluntary? What is it for an obligation to be voluntary? A lot could be said here. Let me just almost stipulate. One could take the attenuated view that a voluntary obligation is simply one that you can intentionally acquire or deliberately avoid. But that would have the repercussion that almost any obligation could be rendered voluntary by simply intentionally acquiring it. Even to take an example of Neil McCormick's, even the drifter who wants a warm meal and a roof over his head on a cold January night could intentionally commit a crime in order to be bound to serve some time in some incarceration time. And yet it hardly rings true to call that obligation to be incarcerated voluntary. The robust and distinctive sense in which a contractual obligation is voluntary, I think, isn't captured by that. I would like to say the voluntariness of an obligation doesn't depend on the mental state of the person who acquires the obligation, but rather on the triggering conditions, the conditions under which an obligation is acquired, and the reasons why we acquire, or why the law imposes those obligations on us. So in particular, I want to say that an obligation is voluntary just in case, that is to say, if and only if, the obligation could not be acquired but for the intention to acquire it. So with that stipulated definition in front of us, then we can say that a contractual obligation is voluntary if it is the case that there is a genuine requirement in our law that the parties must intend to acquire a contractual obligation before they acquire one. So when I say contractual obligations are voluntary, I am simply saying there is a genuine requirement of an intention to create legal relations in our law. There is a question that I'll put off to the side now. I'm happy to discuss it after as to what I mean by intention, because as most of you know, intention in the law of contract is taken objectively rather than subjectively. I could say more about that if you wish, but let me move on in the meantime. Is there, in fact, a genuine requirement of an intention to create legal relations in our law? I've called it orthodoxy, but there are skeptics. Angela appears, at least from her textbook, to be one. Stephen, in fact, in his text, isn't so clear either. In other words, I'm not at all sure he would agree that there is a genuine intention to create legal relations requirement in our law. Professor McCamus appears to be on the side of orthodoxy. His treatise on contract it contains an entire chapter entitled The Intention to Create Legal Obligations. There are some twists and turns in it and some subtleties that I'll have occasion, I think, to come back to in a moment. That treatise, by the way, it always... when I teach contract, I stand in front of the class and there's 60-odd students, and it's getting to the point now where almost everybody has a copy of Professor McCamus's treatise in front of them. And it's no doubt because early in the semester every year, I indicate that I was taught by Professor McCamus. And then they all rush out, right? Thinking they'll get the source. Right? Forget learning it from me, let's learn it from the guy who taught him. So anyway, your sales are good at Queen's, John. There are skeptics who doubt the existence of a genuine inquiry, a genuine intention to create legal relations requirement in our law. And there's good reason to be skeptical. The occurrence, the frequency with which courts engaged in contracts disputes actually engage in a genuine factual inquiry into whether the parties actually intended to be bound, it's very small. There are very, very few cases in which that inquiry is in any authentic sense engaged in. So what are we to do with this? Well, there's no shortage of judicial obiter and in fact, statements to the effect in the law reports that there is an intention to create legal relations requirement in our law. But that's of only so much use as well. What we really need is to see the rubber hitting the road. The proof is in the pudding. Show me some cases where parties fail to, where the court refuses to enforce an agreement because there is a lack of intention to create legal relations. So you get the Balfour line of cases, only so persuasive though, because there are all sorts of policy reasons why we would want to deny recovery for a party who's in a non-arm's length arrangement with somebody else. So I'm going to put those aside. Then there's another line of cases, the most famous of which is Rosen, Frank, and Crompton Brothers, an old staid case. I don't really want to say much about it. But it represents the proposition that, and this is the one I'm going to focus on here, that when there is an express disclaimer, when the parties expressly disavow any intention to create a legal obligation by their agreement, they will succeed in precluding legal obligations. I'm going to take that as a datum of the law. That if you unambiguously express between the two parties that they do not intend to acquire a legal obligation, they won't acquire a legal obligation, a contractual obligation at any rate. I call that feature of our contract law disclaimer sensitivity. Contractual obligations are disclaimer sensitive. They don't obtain if there's a disclaimer present. What I want to do and what I try to do in this paper, and I'll gesture towards it in this talk, is I want to try to take that, what I take to be an indubitable proposition about the law, that there is disclaimer sensitivity, that disclaimers preclude obligations. I want to take that indubitable proposition and try to derive the somewhat less certain proposition that there is a genuine intention to create legal relations requirement in our law. So it's a kind of Cartesian exercise. I'll start with what can't be doubted, and I'll try to, as it were, prove this more doubtful proposition. It's often thought, and some older English textbooks seem to take this view, that one can move directly by way of inference from the proposition that a disclaimer precludes an obligation to the conclusion that there is an intention to create legal relationships, a voluntariness in contract law. The argument would go like this. So here's a simple argument, and then I'll say what's wrong with it. The argument would be, disclaimers are evidence that the parties did not intend to be bound. Premise 1. Premise 2. A disclaimer will preclude a contractual obligation from obtaining. Conclusion from those two premises. Therefore, a contractual obligation requires an intention to create legal relations. At first blush, it looks compelling. The problem is in the first premise, though, right? When there is a disclaimer present, if the only potentially relevant feature of that disclaimer, if the only thing it might relevantly evince or be evidence of is the absence of an intention to be bound, then the inference would go through. The problem is that the presence of a disclaimer is evidence not just of of the absence of an intention to be bound, but also the presence of an intention to avoid a contractual obligation. So these two facts are different. Both of them are evidenced by the presence of a disclaimer. 1, the absence of an intention to be bound. 2, the presence of an intention to avoid a legal obligation. The latter implies the former, but the former does not imply the latter. This reminds me always of Corbyn's in early version of his text on contract, he discusses two naive farmers who are trading a cow for a horse. And they have no idea about the idea of about contract law or legal relations in general. They have no idea the law pays any attention to agreements. And so they have no intention to create, they have no intention to create legal relations, right? But they certainly do not have an intention to avoid a legal relationship because they know of no such beast. They have no desire to avoid a contractual relationship. They don't know of such a thing. Here's the ambiguity here. When disclaimers are respected by the law, when a court denies enforceability to an agreement that includes a disclaimer, is the law responding to the presence of an intention not to be bound? Or is it responding to the absence of an intention to be bound? My paper really just takes off from this point and goes on to argue that it must be responding to the absence of an intention to be bound, that the alternative possibility is not plausible. So let me just very quickly lay out the structure of this, the gravamen of this argument. Imagine two individuals, A and B, making an agreement in two different possible worlds. In the first world, they make an agreement that satisfies all the necessary and sufficient conditions of making a contract. Consideration, offer, acceptance, certainty, etc. All of those are satisfied. In the second world, here's the trick, or here's the key to the argument. The second world is the closest possible world to the first. The only difference, I'm tweaking that second possible world in the following way. The parties have now qualified their agreement, which is otherwise the same, with a disclaimer. Otherwise, the circumstances and et cetera are identical. In the second world, because disclaimer sensitivity I'm taking to be a datum, in the second world there'll be no contract. The question then is, which of the necessary conditions of contracting is not satisfied in that second world? Two possibilities present themselves, right? One, there is a condition of voluntariness that says the parties must intend to create a legal obligation. Two, there is a condition of avoidability that says if the parties intend to avoid an obligation, they will succeed. I want to argue that second kind of, that second condition of avoidability, I'll call it the avoidability thesis, that what the law is responding to is the intention to avoid an obligation, that cannot be sustained. According to the avoidability thesis, which I'm contrasting with the voluntariness thesis is the orthodox idea that there must be an intention to create legal obligations. The avoidability thesis says there is no such requirement in our law. However, if the parties don't want to be bound, we won't bind them. Here's the problem with that argument, the basic problem with that proposition, it seems to me. In our two worlds, the parties do everything the same. The situation is completely identical, but for the presence in the second world of an added intention not to be bound in law by what they're doing. All right. So if taking that to be true, what possible normative legal difference can the presence of an intention not to be bound in that second world make? What is the normative force of an intention not to acquire an obligation in a situation where, absent that intention, you would acquire the obligation? So here's a kind of general sort of principle I'm going to put forward, and I'll have to justify it more in the paper. Suppose it is the case that if you engage in some act, in my paper I call it beta, because Greek letters always make me feel like I'm being way more precise and persuasive. If I engage in some act beta in certain circumstances X, I will obtain an obligation, call it O, a contractual obligation in this case. Let's take that to be true. So there are certain situations in which I can acquire a contractual obligation by engaging in certain acts. Now I engage in that same act beta, but I do it now with the intention not to be acquiring O. It seems to me that that intention not to acquire O is completely irrelevant. It's not going to make any difference if it is the case that that act beta, absent that intention, would generate an obligation. Obligations are requirements, an essential ingredient in which, or an essential aspect or characteristic of which, is that your aversion to having them is irrelevant to you having them. Do I want an obligation not to defame you? No. Do I want an obligation not to exceed 100 kilometers an hour on the highway? No. Is that relevant? Absolutely not. So obligations have that feature, thank you, have that feature that your aversion to acquiring them is irrelevant. Once that is accepted, then it seems to me that we have to also accept that if you intend not to acquire an obligation by doing an act that, absent that intention, would saddle you with that obligation, you haven't avoided it. So that's a very skeletal summary of the basic argument that the avoidability thesis isn't plausible. If the avoidability thesis isn't plausible, the only alternative that seems to me is the voluntariness thesis. In other words, disclaimer sensitivity implies, I'm imagining a syllogism here, disclaimer sensitivity implies one of two things is true, the avoidability thesis or the voluntariness thesis. I'm trying to show in this paper that the avoidability thesis isn't plausible. That then is indirect proof of the voluntariness thesis. There are various counter-arguments that I could go into in the Q&A after. Let me just mention one twist that Professor McCamus, I think, signs on to in his chapter on intention to create legal relations. In his discussion of disclaimers in the Rosenfrank case, he indicates that the reason we take disclaimers to the reason for disclaimer sensitivity, the reason that disclaimers are effective is because the parties have agreed not to be bound. In other words, why shouldn't we just respect their intention manifest in that disclaimer? So my difficulty with the avoidability thesis was I can't see any normative basis, the source of the normative force of a disclaimer. Professor McCamus, and there are others who take this view as well, try to generate the source of the disclaimer's force in the fact that it's part of the agreement itself. It's respected just like any other term in the agreement is respected. This is actually manifest in Section 21 of the American, all right, I'm out of time, the American Restatement. So the proposition then is that the agreement includes the disclaimer. We respect the agreement, therefore we respect the disclaimer. I'll call that the internalization strategy, and I have some answers to that as well, but you'll have to wait for those, I suppose. Anyway, thank you very much.
I'm standing up because the first thing I want to do is to acknowledge my gratitude to the product placement. Oh, it just gone away. an invitation of my own textbook. There it is. You
There it
see,
is,
this is my book here. And so I want to acknowledge my gratitude to Stephanie and Jamie. And I didn't pay for it, not very much, but I'm very grateful for it. I'm very pleased to be here and to honor John and acknowledge his contributions to many aspects of Canadian law, his administration, his teaching and undertakings. And John richly deserves the honor. As a parent, I know the joy that comes of seeing one's children become adults, in particular becoming parents themselves, and providing a grandparent with the estimable joy of grandchildren. As I mentioned before, John and Stephen were my students. Actually, Rob MacDonald at the back, too, is my student. Rod was my first graduate student to become a dean, John my first undergraduate student to become a dean. And I have much the same, though attenuated feelings when you see your students make good. It's a very nice feeling when you see your students having very successful careers. One of the great joys of teaching in a law school is that one's students becomes one's colleagues. And so you can enjoy the students long after they have become members of the profession. I've been asked to comment on these two papers. They're very different papers in some respects, but also in some respects quite similar. First, I'll spend some time on Stephen's paper. Stephen starts his paper by observing that Palmer said that finding a workable scheme of classification is one of the most intractable problems of the law of mistake. Two things are important about the law of mistake. One is that it is a last-ditch argument of counsel. When all else fails, the counsel tries mistake. Students, I find, coming into practice, have this idea that things like reps and warranties are labeled in some process. I point out to them, they aren't labeled till you as a lawyer put a label on them. Clients come in and make some unhelpful statement like, our supplier screwed us, what can we do now? Well, representation, a warranty, or if all else fails, it's a mistake. So the last-ditch argument of mistake, then, I think is important. I'll mention some of the instances later. Second thing about mistake is that there are easy cases and hard cases. And in fact, those are the only two classifications that I think you need. And I think that if you accept, as I do, and Stephen does, and John does, that the analysis of mistake, and frustration too, is a question of allocating risks of loss arising from something that's gone wrong, then I think you need to classify mistaken assumptions, integration, and so on, simply disappears. Different problems, and either easy solutions or difficult solutions. Lots of difficult solutions. The one that I think is the most difficult in the case that I use, this case Stephen didn't mention, but it's a case like McGee and Penn on insurance, where a person makes a statement on an application for insurance policy which is false. Many years later, loss occurs. The insurance company says, aha, you were a bad person, not going to meet the claim. Mistake in one sense, or the argument you can make is a mistake, and you have the Court of Appeal in England going in three completely divergent ways. And so, in looking then at mistake, I think it'd be interesting, and I just made a little comment on my paper, that how do solicitors deal with mistake? I'm a solicitor. I spend my time, as Stephanie mentioned, advising people on how to draft, administer contracts, very important thing that most academics, I think, ignore. And our contracts sometimes drafted for ease of administration. For example, many contracts will establish a relation between two corporations which have to be administered by people perhaps quite low down in the corporation. And then how do you do that? Again, Notice it, for example, in the context of car rental agreements. Notice how the contract is administered. It's given to you by somebody and you're told to initial in those various boxes. That ties into the argument, well, if you agree to take the car without insurance, it's very hard to argue you have the protection that insurance gave you. So those are kind of instances of how the contracts are administered. Let me spend the rest of my time, though, talking about Michael's paper. I guess my concern with Michael's paper is I think that the cases that he uses are not particularly interesting. He mentioned Balfour and Balfour as being situated, of course, beginning of the 20th century, almost 100 years ago, and now all kinds of policies and so on would surround analysis at that time. And then he talks about Rose and Frank. And Rose and Frank, I mean, what I want to show to Michael, I'm happy to show him some documents, is that there are other cases which are actually, I think, more interesting. And in connection with the general issue of voluntariness, I mentioned two cases. One is Walton Stores and Maher in the High Court of Australia, where a tenant was advised, prospective tenant was advised by its solicitor that it could safely walk away from a transaction, the proposed lease. Not so, said the High Court. You induced the landlord, the prospective landlord, to incur expenses, and you're now going to be stuck with the consequences of those expenses. You're going to reimburse the landlord for the expenses that it incurred. Point to raise here is that imposed on some kind of voluntary basis? Is the mere act of getting into negotiations sufficient to expose you to the risk of liability? Second is a decision of the UK Supreme Court a couple of years ago, a case called RTS Flexible Systems Limited and Molkerai, Alwa, Mueller, GmbH, etc. What you have there is a contract, more than £1 million in stake, which the Supreme Court imposed an obligation on the purchaser to pay, even though no contract had been signed and even though the negotiations had been inconclusive. And so those kind of cases, and in my paper I give a quotation from Lord Clark's reasons in the Supreme Court, seem to me to be better examples of the nature of voluntary undertakings. But two other situations I think are interesting. One are what are called letters of comfort. Letters of comfort are used all the time. They're not particularly common, but in many transactions they will occur. Letter of comfort is typically given by a parent to the lender to the subsidiary. We'll typically say, it is our policy to have the subsidiary run so that it pays its debts. Other situations where it might arise would be one from a shareholder giving similar comfort to a lender to the corporation. Letters of comfort are a curious thing because they really, when you look down at, what it's saying is, we promise to do something, perhaps not very much, but you won't be liable at all if things go wrong. And in fact, the recent cases in letters of comfort, one in the English Court of Appeal, Kleinwort Benson, and one in Ontario Court of Appeal, Toronto Dominion Bank, have held those not to create any legal obligations. Question whether it's the wording of the thing or it's intended to have some kind of legal relation. And you can see that in the case of Kleinwort Benson, it was part of a bargain because it cost the borrower 1/8 of 1% more. The other category of agreements are letters of intent. Letters of intent are drafted by solicitors that typically are in two parts. The first part identified as non-binding provisions, and there you'll find the price set out, the terms of the sale set out, possibly outline of an employment contract to be offered to the president of the seller, and so on. But then the binding provisions go on to say, the binding provisions, second part is the binding provisions, and they deal with things like the right of the buyer to conduct his due diligence. Might be a break fee in there. There might be no shop provision, and other kinds of things there. And the non-binding provisions will say, the binding provisions will say the non-binding aren't binding. I don't know how that fits in with Michael's thing, but it seems to me to suggest a curious kind of amalgam of voluntariness, disclaimers, and so on, which might be worth looking at. There's another class of cases which is again of current issue in rather arcane M&A situations. Can you, for example, have a material adverse event clause, a material adverse change clause that is so wide as to make the purchaser have little more than an option to buy? And I mentioned some cases in Canada where you have such wide excuses for a purchaser that perhaps there's not much of an obligation to do much. And so my final kind of comment is this, and I'm sure I know that I wish that academics would spend more time looking at what solicitors do. We do interesting stuff. We look at the cases and we say, yeah, that case creates, rocks and shoals for my client. I have to keep my client away from it. How do I do that? For example, none of the casebook I looked at, which is Stephen's casebook and John's casebook, doesn't produce a force majeure clause. Look at a force majeure clause. They're all pretty standard. There's some really bizarre ones. If you look at the force majeure clause offered by Ontario Power Authority on its website under the FIT contracts, you'll find some most extraordinary language there. Look at it. Look at, for example, the concept of events of default. Events of default are developed by solicitors to deal with the perennial problem of, do I have to perform in light of the other party's breach of contract? They come up in loan agreements, all kinds of situations, and they very often have a graduated response. In a loan agreement, the lender doesn't have to make any further advances if a certain event occurs. A more serious event occurs, the lender's obligation to keep on with the loan is discharged, and the lender can call the loan. So it would be a plea to the Academy to look at what's going on in practice. We do interesting things, and if somebody wants to look at some agreements, I'd be happy to show them some. One of my jobs at both Airden Burles and at Stipends was drafting up some annotated agreements. I can give you an annotated letter of intent, annotated loan disclosure agreement, annotated asset purchase agreement. They're fun stuff to look at because you can see, hey, this is how they do this stuff. They've read this case. For example, one of the major problems for solicitors in employment practice is how on earth do you vary an employment contract in light of the crazy cases that courts of appeal have been saying there's no consideration given by the employee if the terms of the employment contract are changed? How do you deal with that? If the courts say you must fire the employee, threaten to fire the employee, that's crazy HR practice. So how does the solicitor deal with this? Come and talk to us. It's neat stuff. Okay, thank you.
Okay, we have just a couple minutes left for Q&A because of our late start, so we might have to continue that Q&A into the health break, but do we have one or two questions?
Shock them into silence.
Okay, well, maybe we'll give you a couple minutes to think about that, and we'll continue the discussion at the health break. I know you'll all join me in thanking our panelists. Oh, do we have a question?
Oh, there's a question?
Oh, okay. Hold the applause.
Thank you all for coming in to speak this morning. It's a question mainly for Stephen. At the end of your contribution, you mentioned that you think that mistaken assumption and frustration should be treated identically. And I was wondering if you could just elaborate on that thought a little bit, because isn't the important distinction that in cases of mistaken assumption before entering contract, there's at least the possibility that someone, with enough deliberate inquiry could have learned about it, whereas with frustration, it's possibly something that could never have been known because it's a future-oriented event.
Yes. Yes, well, thank you for the question. The distinction between mistake as to existing fact and mistake as to future events, though, as your question implies, apparently vivid in theory, tends to be blurred in practice. So take, for example, the leading case in English law on frustration, Krell and Henry, involving a mistake as to whether the king's coronation procession would take place. The king fell ill with appendicitis and the procession was cancelled. Now, some of the contracts were made just before the announcement of the cancellation of the procession. Some were made just after the announcement was made, but in ignorance of it. From the point of view of a party who's agreed to pay tens of thousands of dollars in modern currency for a room with a view that is now useless, the problem is identical. Indeed, even the traditional frustration cases could be analyzed as mistake cases because the king had been suffering from symptoms which in retrospect are known to be symptoms of incipient appendicitis. And so even those cases that are analyzed as frustration cases, that is, will the procession take place, may be capable also of analysis as mistake cases, mistake of fact, that is the king now in a sufficient state of health as will enable him to carry through the two coronation processions that were planned. So that's one answer to your question. Another answer would be that the collateral problems are identical in both kinds of case. So in both kinds of cases, there's a need for partial relief. There's a need for enforceability by the non-mistaken party if that party desires to enforce the transaction. And there are problems of reliance and restitution in relation to events and transfers that have occurred between the parties on the faith of a transaction that is subsequently set aside, and some technique is needed for dealing with these questions, and they are identical in the two kinds of case, and so there's a strong case for a common set of principles. And perhaps just I might add one more a practical advantage to seeing the two problems as identical, and that is, as I mentioned, English law, although quite reticent in relation to relief for mistaken assumptions, has been quite generous in relation to relief for frustration, and indeed has now recognized that relief for frustration depends on wide considerations of justice that require the court to exercise a wide power. So the recognition of this in relation to frustration would carry over into mistake if it were accepted that the two problems are in substance identical. So the generous approach, comparatively generous approach of English law to frustration could beneficially be carried over to encourage an enlargement of the powers of the court in relation to mistakes of fact.
Thank you.
Thank you for the question. So let's go back to that applause stage and thank the panelists, please.